the defendant and his mother, Linda Montoya, I think it's very obvious that they are relevant. Many of the conversations deal with either some of his initial conversations with Sergeant Behill when he was being questioned at Santa Fe Police Department. Others are clearly part of a defense scheme. Others just...
Part of a what?
A defense scheme. So maybe a tactic or something that he is, saying that he is actually saying. So he knows that the phone calls are recorded. I think there's a sign at the jail that says that there is the warning at the very beginning, and so one of those conversations or one of those things is him actually saying, for whoever's listening, this is what happened. There were some complaints about what could be heard in the background. Mr. Roybal from our office, he actually did his best to remove any of that background noise during the editing of those conversations down to the relevant seconds or minutes in some of those cases. And so really it sounds as if the fear is purely speculative at this point, Your Honor, that a lot of that fear from defense is that you can hear a jail cell close or anything like that. You can't. And honestly, Judge, there's a little bit of background noise. I feel that when listening to it, there's actually more background noise coming from Linda Montoya's side of the conversation than from the defendant. So, Judge, they are relevant. The foundation's been laid. Just a quick aside on some case law. I don't have the number. I can look that up very, very quickly, but it was actually State of New Mexico versus Andrew Romero, which is an extremely high profile case out of Sandoval County, tried by now a district court judge in Albuquerque and one of the premier defense attorneys in the state, Mr. Clark. And in that case, on appeal, they talked quite a bit about some of those jail calls. The relevance was very clear, but the Supreme Court actually made a comment about some of the foundations when laying that, and it simply said, judges, that it was a particularly low bar because it is just voice recognition. That's what it comes down to, and the state has satisfied that foundation. I think looking at the edits that the state has provided, they are all relevant. There is nothing that is unfairly prejudicial in there. Of course, there is going to be prejudicial material in there, Judge. That's called evidence, and it is, I think, the court's duty to sort of balance that, looking at the probative value versus the unfair prejudice, Judge. And the state has actually done with the number of hours, and there are hundreds of hours of jail phone calls that the state has listened to and edited down to essentially a little over 11 minutes. The state has really taken upon itself to make sure that there is nothing unfairly prejudicial in there, that it is just relevant evidence that the state really does feel that we are entitled to introduce in trial. Thank you.
On behalf of Mr. Apodaca.
And Judge, I don't want to keep honing in on the probative and prejudicial and basic rules of evidence here, but I mean, jail calls, we worked very hard, first of all, to dress them up. It's a jail call between Mr. Apodaca and his mom. Okay, that right there is going to raise up a red flag. Why would Ms. Montoya be recording her own son? Then we're also dealing with, I mean, the recording itself, where you can hear background noise, you can hear just a bunch of people in the background talking. I mean, I understand we listen to a lot more jail calls than the average person, but it still sounds like a jail call and I think a common person would believe that these are in fact jail calls when they hear all the background noise and all that. As I have proposed to the court, I think the best resolution here, if we are going to introduce these, is to just simply get these in through the detective. Just say that the detective can testify to that these statements were made between Ms. Montoya and her son. We can leave it at that. But if we go into the calls, if they hear that, I think there's a strong likelihood that the jury will believe that these are jail calls, and it will negate everything that we've done.
Is there a law that prohibits them from knowing that? I understand your concern is that they might use that information to form some kind of opinion about your client, but this jury has already seen him taken into custody on the day of the incident. So they've already seen that video. They know he was in police custody. So following down that road, that thread,
Well, he was in police custody, but to hold somebody if they believe that he's been then sent to the jail, and then they could assume that he's been in jail pending this trial, and they'll think that, there was I don't know if they know the terms of art, prevented detention and all that, as far as New Mexico law is concerned, but they may then assume that he has been in custody pending trial since 2022 because somebody believed that he was a danger to the community. And that's my concern. I think that is going to, and then that goes into the rules of evidence regarding probative value being outweighed by prejudicial value, 402, 403, all of that. We're pulling up exact law right now in regards to knowing whether a defendant is in custody. But the whole purpose of this is to, I understand that the state wants to get in certain evidence. And I don't think that these messages are necessarily all that prejudicial to us. There could be some impeachment concerns here. But what we are really worried about is the jury understanding that he is in custody.
okay. I said yesterday that I wanted to listen to these in the form that they would be presented before I rule. While we're listening to these, I don't have a copy of the case that you cited in front of me, Mr. Long, so I need that. And then if there's a law that the defense wants to argue, I'll hear that as well. Go ahead, Mr. Long, if you want to play those.
Let me just make sure that I'm doing and I think maybe just for quickness, what I will do is there is all of these phone calls have been identified by a alphanumeric hash, and so there are numbers and letters, and the last four are always going to be unique, and so I'm just going to say what those are. There's going to be one where the call is actually edited into 3 chunks, and I'll let the court know on that. All right, so this first one is going to be, last 4 is going to be 3F as in Frank 17.
So here's 5 things that you should know about that night. You texted me and I said I was sick, correct?
Right. You know what?
That I was sick.
Mm-hmm.
And then I didn't have my phone because it was charging.
Yes.
3, the text messages are not mine. 4, I was handed my phone that day after Kiara did whatever she did.
Uh-huh.
And then 5, I was at AP Wireless the whole time.
Mm-hmm.
So the detective coercing me into saying something that I didn't even do.
And Judge, is there any way that I could get this monitor at the podium up, just because the audio, I'm having trouble figuring out when the audio is ending. I can't actually see it on this computer screen.
Okay.
Thank you. This next one is going to be 1C as in Charlie 92.
I know I'm innocent. I know I didn't do anything. The text messages aren't mine. Everything that I've been saying is the truth.
The next one is 9CCA, so 9 Charlie Charlie Adam.
That night, I woke up late, asked for a ride, because Kiara gave me a list, a grocery list, to go to Walmart to get some groceries because she wanted to make a stew or something.
Uh-huh.
So I did that, and came back, had the groceries put in and everything, but left my phone in the garage.
Okay.
And then and then I came back because I cooked some chicken strips. I think I remember telling you about the chicken strips that I like.
Mm-hmm.
You remember them?
Yeah. Well, I don't remember the name, but.
Then after that, Grace came over. Kiara went into the main house to get prepared for something, and she took her sword with her. You hear me?
Mm-hmm.
You know what I mean?
No.
You know what I'm saying?
I'm hearing you, but.
Yeah. So, and then after she did that, she went to the park and walked. Well, what she told me was she went to the park and walked around with her sword unsheathed. There was going back and forth to that area, and they didn't even do anything.
Uh-huh.
So how does that sound when you have somebody else there walking around with a sword unsheathed?
I don't know.
At the park in the middle of the night.
Because we didn't hear nothing.
I know. But after that, I was trying to go to bed.
Mm-hmm.
As I'm trying to go to bed, when Kiara was over there using like a blade and rubbing it against my back. A knife.
Mm-hmm.
I did eventually get sleep for an hour, and then I had my phone thrown at me, and my phone was at 14%.
Mm-hmm.
I thought it was charged when I gave her the phone after I texted I'm still sick to you. So I gave her the phone. Are you hearing me?
No.
Are you
Uh-huh. Are you there?
Yeah, I'm still here. Are you hearing me?
Yes, I'm hearing you, sir.
I know. Okay. Well, and then after I did that, I called y'all because I was supposed to leave.
Mm-hmm.
Then I went back after the call. I went back inside the garage to start packing up my stuff. And then that's when she told me that she wanted me back in a few days. I already made my decision that I was going to leave the relationship.
All right, the next one is going to be 59D1, 59 David 1.
And I was through Isaac Apodaca.
Yeah.
And then the other one, like I told you, I don't remember if I told you, but he had another Facebook account called Null Void.
Mm-hmm.
And she's like, who's Null Void? It's just a Marvel character.
He's a villain.
Yeah, but I just said he's a Marvel character. And then she's like, oh, okay. And said, I got text messages at night. So I sent them to her.
Yeah.
Yep. I sent them to her. I also sent her the one from Facebook, Isaac Apodaca, because I blocked that account because it was being hacked.
Yeah,
So actually send it to me.
I'm still trying to figure out who hacked it because it didn't seem like it was her. It didn't seem like it was Mary Lou.
The next one is 5B6C, so 5 Beta 6 Charlie.
I texted her I texted Grace that morning telling her we're in danger, me and you. Let's get out of here as soon as possible.
The next one is 3EF8, 3 Edna Frank 8.
Here's something that I want everybody to know, whoever may be listening. I'm going to say this. Kiara McCulley is a manipulator, a narcissist, and a person who knows how to use words, the same type of words that there's words that the Russian KGB agents use, sleeper agents. There's certain words that trigger me that she used to use, like "prove your love to me." That is one word, that is a phrase to me that makes me say things on impulse without thinking of the consequences.
Okay.
That's why I say that confession is a bogus confession, because when the detective said that, I said something stupid thinking that I was going to go home on the promise that he said I was going to go home.
Oh, okay.
See, I had nothing to do with this whole situation. Nothing, except calling 911 after you called 911.
Yeah.
That's all I did.
Next one is 1C97, 1 Charlie 97.
Yeah, this whole situation with what I'm facing is annoying, because she went and did everything alone, on her own, willingly and out of her own free will.
Yeah.
And she's trying to play it out like I'm Charles Manson.
The next one is 72D9, 72 David 9.
The day which everything happened.
Mm-hmm.
And I told her I didn't know anything was going to happen.
The next one is going to be part 1 of 90E7, so 90 Edward 7.
He's trying to push up the story and say I'm trying to help. I helped her. I did not help her. I wish I could talk to my attorney today, but
No, so you'll see her on Monday.
I know. It's just that whole story that the news is portraying. It made me feel horrible.
Because there was text messages.
Yeah.
That's the last time I heard about it.
Yeah, they said
It was on the newspaper.
They said there was text messages, but the text messages weren't even mine. And you can, if you were able to see the text messages, you would be able to tell, like, oh, this is so-and-so. This is Kiara talking. You know what I mean?
Okay. Yeah. That's so much stuff. Hold on.
Huh?
I'm trying to look for it.
Okay. It's just messed up that I'm dealing with a situation that she got me involved in. I have hope. Pray to God. I have nightmares about what.
Hold on.
The next one is going to be part 2 of that same conversation.
I didn't plan it. I don't get how I am suddenly involved with this whole planning situation.
Next one is part 3 of that same conversation.
That morning, I just felt like something bad was going to happen, and that's why I called y'all, and I called y'all to pick me up.
Mhm.
I know you guys couldn't pick me up because you guys were out delivering, but I don't know what else would have been my other choice to do.
Mhm.
I was trying to contact everybody on Facebook to help, but nobody responded.
And the next one is going to be 055F, so 055 Frank.
I was going to the police station. She was smiling, singing, laughing, and everything in the police station while I was just there. It's like, why am I here? Why am I involved? I was getting frustrated, and I don't know if the detective talked to you, but the detective told me that I had to back up, give him some space.
Mhm.
So I was getting upset. So I wasn't the one involved.
And the final one is going to be E1, E2, so Edward 1, Edward 2.
What I was going to say was, they're going to go through the text messages, the thing, with the verbiage and the wordage on how I used it.
Yeah.
I check everybody to see how I texted.
Yeah.
Those texts don't match the same way I text theirs. The case
Yeah.
is done. But they
I-
said that it was a willful act to commit, but they are seriously doubting that I was even a part of it.
And that's the totality of the calls, Your Honor.
Let's go back on the record. We reconvene. Counsel, could you have a seat for a moment, please? We're back on the record outside the hearing in presence of the jury with counsel and Mr. Apodaca present. The court had recessed and took some time to review 4 different cases as well as the rules cited by counsel in their arguments. The issue before the court is the state's request to be able to introduce certain conversations between the defendant and his mother. The objection comes as the concern by the defense that the jury, knowing that these might have been jail calls, would unduly prejudice the defendant, that the probative value of the information and the statements made is outweighed by the prejudicial knowledge that the defendant was in custody at the time that the conversations occurred. The state offers these, as the court's understanding, for really 3, I wrote down 3 reasons. One is that the statements are contradictions to statements made at the time of his interview with law enforcement. The second is that this is statements that are different than those made at the time of his interview. And third, that this is some type of an evolving narrative by the defendant over time of his involvement in and participation or non-participation in the death of Grace Jones. The court, having reviewed the Jones case as cited by defense, as well as the Romero case, the Rodriguez case, and the Chavez case in Rule 5403, makes the following findings and conclusions. First of all, with respect to the quality of the recordings themselves, the quality is, some of them are better than the others. The way the audio has been redacted, it is difficult at some points in times to hear the voices, particularly that of Mr. Apodaca in responding to or initiating statements to his mother. With respect to the background noise, there is background noise in the statements, but it is not clearly, it appears to be static or other chatter, but the court was unable to hear anything that identified that the background noise was coming from a detention facility. Defense counsel has argued that that would be the natural assumption. The court disagrees. There's many reasons why. There may be poor quality, and even for the sake of argument, if a juror or jurors came to the conclusion that the calls were coming from a detention facility, having reviewed the relevant case law, the court finds that that fact in and of itself is not debilitating or unduly prejudicial to the extent that would bar presentation of the information. The court finds that the information is relevant under one or all of the three avenues presented by the state. The court finds in weighing the potential prejudicial nature of the location of the defendant during the time of the calls, it does not outweigh the probative value in the state's argument that Mr. Apodaca is as an accessory also has been charged with the first-degree murder of Grace Jones. In reviewing the case law, particularly the Romero case, most recently, there is no prohibition in our case law in New Mexico that would prevent the jury from having that knowledge, even if they came to that conclusion from the limited background noise in the calls. The defense argues that the natural assumption that the jury would make is that he's in custody. The court disagrees. There are many reasons why phone conversations are recorded or could have been recorded. That will be basically an unknown to the jury as this is presented as to how the recordings came into the possession of the state. Give me just a second. The defense has argued that the jail calls, the knowledge that the conversations occurred while the defendant was in custody is tantamount to our law in New Mexico that prohibits the defendant being brought before a jury in shackles or in a prison or jail clothing. Those are different. The prohibition is to prevent something that is occurring during the course of the trial that would prejudice the defendant. He would be the only one sitting potentially in the room in that state with being held in shackles or in jail or prison clothing in the open forum of the trial. That is different than discovery that has been developed and shared between the parties relevant to the issues that the jury ultimately has to decide as to whether or not there is any culpability on the part of the defendant with respect to the charges he is facing. Accordingly, the court finds that the 11 snippets or portions of much longer recordings do not unduly prejudice the defendant, that their probative value outweighs any prejudice that may may inure if the defendant, if the jury or a juror concludes or assumes that the defendant was in custody during the recording of the conversations. The court will allow the 11 sound bites to be played before the jury as part of the state's case in chief.